Woo! Yeah! Come on, everybody.
Thank you so much for coming tonight. My name's Tom Kirker. This is Josh Sanford, my co-host,
Happy to be here.
and our guest, Will Moye. We're very lucky. This year, our good friends at Supio are sponsoring the Sue Everyone Tour. We are traveling the country. Josh and I are doing one show a month in a different city, starting with Houston because it's our home. And we are having this conversation with plaintiff lawyers about the future of law. And I want to start out this discussion with a question, and that is, how many car accidents do you think happened in Houston or the greater Houston area in 2025?
Go ahead.
66,400.
Okay.
Oh, no! You ruined the game!
That is...
Nerd alert!
Yeah, that is extremely close. So, yeah. Yeah.
Wait, I think she's cheating, but
Yeah, it was a mole. It's okay.
The highest is Dallas at 32,000.
66,400. That's your final answer?
It's like approximate.
No, that was great.
Yeah, it's really close.
So the number that our research showed was 67,500. So right there. So 67,500 cases. Our representation to you is that in 10 years, that number will drop from 67,000 to 15,000.
Does anyone here completely disagree with that and think that's absurd? There's no way that car accident numbers are going to go down. You got to speak up because we got lights. All right, no one says that. So why is it going down?
Automation.
What kind of automation?
FSD. Full self-driving.
Okay, full self-driving. What was the other one? Yeah, safety features. Okay, great.
Yeah. I don't know if anybody's been to Los Angeles or Austin in the past 12 months.
San Francisco. Scottsdale.
And have been in a Waymo.
Can we have Waymo hands? There's one, two, three, yeah.
Yeah.
How many rides do you think Waymo was doing, let's say 9 months ago? Anybody have any idea what the volume was? Pardon?
Almost nothing.
Okay, that's a good guess. Anybody else? Not in April, they were doing 250,000 rides per week.
So, Josh, if they were doing 250,000 rides a week in April, how many are they doing now?
Oh, I'll tell you how many they're doing now. Let's have a show of hands. Who thinks they were doing, by the end of the year, Waymo, 450,000 rides a year in the U.S.?
A week.
Per week.
More.
No. I gave you the answer. The answer was hidden in the question. Raise your hands. They were doing 450,000 rides a week. They doubled.
Oh.
Yeah, thank you. Whoa, you're like, no way. It can't be. Yeah, so in 9 months, they doubled from 250,000 rides a week to 450,000 rides a week around the U.S. And you're like, who cares, right? You have two questions. How many rides will they be doing by the end of 2026, according to what they promised their investors? And obviously, they're never coming to Houston, right? Because it's a different kind of driver here, right?
They're on their way, aren't they? Starting that in a couple months?
Oh, I don't know. That question isn't going to be asked for like 18 more seconds. So just keep eating barbecue and shut up and answer the first question I asked, which is, how many rides will they be doing by the end of the year?
2.5 million.
Oh, okay, so we'll edit that out. That's a stupid answer. That's so high.
Whoa.
They can't like 5-tuple in a year, in 9 months.
Is it number of rides or is it number of riders that's increasing?
It's number of rides. Just give me a number that's really round, like so round.
$1 million.
Who said that? Okay, we don't have any prizes, but y'all are both right if you're both telling the truth. It's 1 million rides by the end of 2026. And someone asked, when are they coming to Houston? Was that me? I think so.
They're already here.
You're already here.
Yeah, they started like 2 weeks ago.
They just
Yeah.
started. And I saw one for the first time about a week ago.
Has anyone ridden in a Waymo? We got 1, 2, 3. So for the podcast, there are like 900 people here. And What? That's my first laugh? For real? Oh, okay, whatever. It's like 1,000. 3 or 4 rides. My hand's up. I've ridden in a Waymo. It's like weird for the first 20 seconds. Tommy's ridden in one.
Yeah, a bunch. It's weird for the first 20 seconds, and then it's the safest ride you've ever been in.
Yeah. It's like Will right now on our podcast. He's like, he doesn't even know that it's dangerous. He's like totally asleep. We have a guest, Will Moye.
So,
Yes, hey, hello.
Okay, we'll come back to him in a few minutes.
yeah, so that's just laying the foundation. So the topic of this podcast, the theme of this tour is, what are we going to do as a plaintiff's bar, or even if you're a defense lawyer? And our bread and butter for the past 25 years has been MVAs. And when that goes away, and goes away for a good reason, in the sense that we want safe roads, we don't want accidents to happen, but also we all have to make a living, what are we going to do?
Product liability.
I appreciate that. Thank you. That's part of it.
Slip and falls.
Okay, we're doing. This is being answered right now. Yes, go on.
Jones Act cases.
I
Yes.
love Jones Act. We don't have those where I'm from in Arkansas. We don't have a lot of coastline.
Will is chomping at the bit.
No, I was going to say products, but for those of those folks here that are curious what's going to happen, it's going to happen. And for those of us that were burdened with the practice of the law more than 25 years, we remember what happened. Speaking of products, what happened to auto products? So things get fixed either where? In a courtroom or the boardroom, right? And the folks like Michael Watts and Frank Branson and Rob Ammons in this town and other people around the state that did a really good job of showing the defects associated with automobile manufacturers and how they were leading to deaths and injuries, it changed. So what happens now? There's not as many product liability cases because ESC was invented. Electronic Stability Control kind of eliminated rollovers from a driver error standpoint. It is a massive change. Roofs got stronger, side curtain airbags. Side curtain airbags and ESC eliminated most of auto product claims in the country. And every products lawyer that was doing this in 2000, 2005 during ATX, Tire, Firestone rollovers, what are they now? Truck lawyers. Because they don't have a docket, because the claims no longer exist, because safety engineering has eliminated the risk for the most part on a design claim. There's still manufacturing cases. Obviously, if you get a manufacturing case, sign it up because someone screwed up, they failed to follow the design. Those are fun. Design cases, monumentally difficult because the design is much safer. So what's going to happen with automation is exactly that. A death claim is going to be a serious injury claim. A serious injury claim might be an injury claim. An injury claim might be a minor injury claim. The minor injury claims are gone. It's just going to happen. It's going to be a function of change. And it is boardroom or courtroom. But the reality, too, is legislature. So for the, I hate to call it car wreck crowd because I think it's disrespectful, but the reality is a car, it is a wreck. So it's car wreck litigation. We're going to have two things that are going to eliminate the volume. It's going to be our friends in Austin who are going to change the statutes or create statutes rather that eliminate the ability to bring these type of claims.
Y'all are supposed to boo now.
Yeah, boo, boo. And
Yeah,
for anyone in Austin sitting in the state legislature, when I show up to testify in 2027 against tort reform, I'm not a sue everybody guy. I only sue people that deserve it. So, take my testimony very credibly when I show up and argue against tort reform, which I've done before. But that's coming too. But between the function of legislative change and technology change, this 15,000 or 1,500 figure is an accurate one. That's what's going to happen. So the nimbleness, the creativity, there has to be an embrace of what are we as a trial bar going to do different? It's in front of us. It's obvious. You can look at two things. If you look at the legislative change, go find a med mal lawyer in town. Good luck finding one because in 2004 it went away. Legislative change. And then from a comparison of what happened to an entire, not profitable because it shouldn't be looked from that standpoint, but the reality of there was legitimate complex litigation that existed in Texas in 2000 that doesn't exist now, that wasn't legislative. It was safety-related changes, and eliminating a lot of the human error on the roadways is going to change car wrecks forever.
And that really should be our mission. Like, we should be putting so much pressure on every industry that they improve their behaviors in a way that eliminates liability. That's what we
Courtroom and
want.
boardroom.
I got teenagers. I don't want cars to be dangerous. Do you say greed or agreed? Because those are very different things. Okay, we got 2 for agreed and 1 for maybe greed.
Mike Strike has a question.
Mike.
I've got a bigger question. What do you think is a bigger threat to the run-of-the-mill PI lawyers? Full self-driving, private equity.
Yeah, so it's very hard to separate those because what's happened over the last 15 years is that there used to be a moat around large-scale MVA acquisition, which is if you could afford to be on TV, you could get the cases. And if you could get the cases, you could get all the cases. And then once PPC and LSAs became a thing and you could start buying leads, then there was no moat and everyone could bid. So what happened to the price? It went up and up and up. And you guys have seen your cost of acquisition on decent motor vehicle accident cases basically double in the last 5 years or maybe 6 years. Private equity is starting to get into it. They've started to fund because they've seen that not all mass tort dockets return a profit for them. So like, why not get into MVAs? And then states all over the U.S. have allowed outside capital to come into the space, and also like just structuring firms like an MSO rather than some sort of
Real law firm.
real law firm or like something that's structured under Arizona or Utah or DC. And so, yeah, the cost of acquisition has gone up, but I don't think you can really separate those two because for the players in the space who are good at volume, they want the margins to be squeezed. They want margins to go down because that will squeeze you out. Because if you can't make a profitable firm on a 15% profit margin, and they can, because they're, like relative to you, they're bigger, then great. They don't care if margins go up. They'll pay more for their CAC if you stop advertising. Yeah, hard to say, but you can't separate it. Do you guys know the math on self-driving vehicles in terms of their rate of accidents? I want you, I don't know what your name is, but shut up. And everyone else, if you know, tell us, compared to a regular human driving a car and Waymo driving a car, what is the frequency reduction?
92%.
You're so close. 98. Oh, okay. So now when you get that far down, you're like way off. They're 11 times more safe, which means I think that's 88%. I'm not that good at math. I'm a lawyer, so I know about thirds and stuff like that. Waymos are 11 times safer. So the larger percentage of the downtown population that's in a Waymo exists, like you're going to see a dramatic reduction in accidents. But there's this multiplier effect, which is that once Waymo cars are passing each other, they're not going to hit each other. Ever. Hardly ever. I mean, maybe it's a great case. But you're going to be out of a docket.
In the first car, and by the way, Waymo is a catch-all term.
Yeah.
There's going to be, if you look at Tesla, they have full self-driving. There's going to be a number of different softwares that come with whatever car du jour, whatever the car du jour is. And the very first line of vehicles that are going to be fully automated is going to be the 18-wheelers. And, for anybody who has a MVA docket, we all know, or generally speaking, the small cases pay the bills and don't really return any profit, but you get your one big case a year, 2 big cases a year, 1 big case a quarter, or whatever it is, and that's where you're really making all of your money. Those are going to be the first to go away. Now, I'm not suggesting that, maybe in the transition period, the machines are going to mess up and you're going to sign up a case now with a defendant that's Google that has a $100 million policy because it's Google. But as time goes on, the tail of accidents will get smaller and go away.
Yeah, and they will get smaller. I don't think, though, there's an elimination. I don't think there's anybody that's credibly saying it's going to eliminate until it's fully automated, completely autonomous, no human element at all. Every car on the road is the same, then there's no accidents. as long as there's a human element involved, there's going to be accidents. Because from perception reaction time, from a pedestrian walking in front of a car, we all know how automation works. There's a bunch of cameras that get sewn together. A computer makes a decision on what to do. It does it. It has an output. But the reality of that anticipating all human negligence, all human elements is not a possibility. It can mitigate but not eliminate. So, my view would be that we all know what's coming. What are we doing to address it? If the volume goes down and there's not the frequency of car wrecks we have now, if you're a lawyer that does a lot of automobile litigation, either through personal lines or commercial lines, good cases versus maybe great cases with not enough insurance, what do you do to be a leader in the industry? What do you do to be the person that gets those cases? What do you do the person that has those cases does well for their clients? The easy answer is go try cases. Become someone that the insurance company is going to know you're a person that will try a case. And to distinguish yourself and your law firm amongst the mass of everyone else that's running an artificial intelligence demand, that's uploading medical records, that's getting some stuff right, hallucinating other stuff, signing it, sending it out, and asking for the policy limit when it's min limits, magnificent. That's not going to work anymore. Frankly, it shouldn't work now, but that's an editorial I'll offer at a later date. There is an opportunity to separate yourself and your law firm from the masses by developing a reputation of they know who you are, they will know you will try a case, and your case will settle as a result.
Will's an idiot. How many 9-figure cases have you resolved?
When I was paying them or how did I settle?
When you were paying. No, when you settled them.
I was paying, I don't know.
No, right now.
Several $1 billion.
No. Listen,
There's people in this room.
Since he joined the right side, he's only settled one 9-figure case. Am I right?
How many do we sell? One?
Two. Okay, that's only two more than me. Yeah. I'm like, why would you listen to this guy? Yeah. We're basically the same guy.
Yeah. Two.
Yeah, no, you make a really good point. And like everyone who went to law school, I hope, went to school to figure out how to help people, right? And so if there's a way for you to get better at your craft and help people, you should be 100% laser focused on that.
Yeah, because
and it doesn't take volume to do that. It takes skill.
No, that's right. And as automation comes, what happens? They become more expensive because they become expert intensive from a downloading, a reconstruction. If you're going to make a products claim against the auto manufacturer, did you have, was the LiDAR and other type of onboard detection systems that kind of generate the data so the brain reacts to the data and stops or starts or turns or brakes? Those are going to be embedded products cases, and those are going to be expensive with an outcome that might not be. It's going to be a products case, and products cases are expensive. So developing a skill and trying cases, frankly, costs what? Nothing? A legal pad and a pen and a clean suit to show up and try a case with? That's what it costs. That's the reality of it. So getting that skill set is a huge monument, and people have heard me soapbox before, is that I think that separates the concepts of what we're doing as lawyers the right way to show someone that we're going to go, not just fight, a good fight, but literally have an outcome that's lifetime determinative for someone because you have the courage, the skill set, and the ability to go change the outcome in front of a jury.
So I 100% agree with that. It would be super awkward to disagree with that. I would say also that if you don't know how to do that, you should be partnering with someone who does. Like, don't take your best case and think, I'm going to try to get 100% of the fee and maybe I ruin this case for my client, but I want 100% of the fee when there are people like Will around. And I mean, he's an odd bird. There's not a lot of people like Will, but there are great lawyers around. You should be working with them if you have a great case. Like, you should be maximizing the value of every case and not treating your docket like a mill that you can settle as quickly as possible.
Yeah, another topic that I want to bring up is thinking about different angles. For instance, we brought up products cases. At Kirker Garcia last year, we had a medical malpractice case come to us. We don't practice medical malpractice.
Can I interrupt?
Yeah.
Say I was going to bring that up.
Yes.
I was already in line on that case.
Yeah. So we had a medical malpractice case that came to us. The way it came to us, the case was already in litigation. During the plaintiff's lawyer, who was our co-counsel, was taking a deposition of a nurse the nurse said something to the effect of, hey, I was doing my job. I thought this machine messed up. Okay. Obviously, we know how hard medical malpractice is, $250,000 cap. Ended up flagging that issue, contacting Kirker Garcia. And this isn't just a plug for Kirker Garcia. There are a lot of great firms. But long story short.
I mean, it's a little bit, but we'll edit that part out. The edit will be like, this is a plug for Kirker Garcia.
Yeah.
This edit brought to you by Kirker Garcia.
But what he's leaving out of this is the lawyer, the medical malpractice lawyer, who had the case, who had and has finally got resolved. It's not just some Joe Blow off the street. It's one of the best medical malpractice lawyers in the area, if not in the state, if not in the country. Did an incredible job on the medical malpractice side. The other thing that's left out is the defense lawyer for that anesthesia group was smart enough to say, because it's a horrific case, horrific injuries. The guy's, 26 now, basically quad brain damage. The defense lawyer did everyone a favor by saying, F you, this wasn't our people, that's that machine. Now, that doesn't happen very often, but when it did happen, the med mal lawyer, who is one of the best, like I said, one of the best you'll ever meet, realized, I need to take a product sample. I've talked about that case to other med mal lawyers since then without saying names, without saying anything about it.
And obviously, without saying the settlement amount, because you were kind of getting on us about it.
Yeah, it was confidential, if I recall correctly.
Well, not anymore. I've heard a lot of numbers.
Seriously.
No, I didn't say anything. It'll be edited
That
out.
wasn't the right number, but it was confidential.
Yeah, confidential. The point is, we need to keep our eyes out for other practice areas. Josh and I formed a firm about 2 years ago. In-house, we're not working on a single PI case. We have...
See, Kirker, I disagree. The point is, that brilliant med mal lawyer...
No, we're editing this out. Y'all don't even listen to this guy.
To pick up the phone.
Yeah.
To me, that's
Agreed.
the bigger point.
Yes, agreed. I agree 1,000%. I agree.
Yeah, I do. But also, can we get a bouncer? I mean, this is like insane. He's like, he told Tommy he was wrong. I'm Tommy's law partner. I don't tell him he's wrong. I'm like, oh, whatever you want, man. Okay.
Yeah, but it's not a pitch, certainly not for Kirker Garcia. But there's a...
No, it's a pitch for Will Moye.
Yeah, no, it's
People,
not.
focus up.
Well, look, I guarantee if you call me and you ask for good lawyers in town, I'll give you a list of them because my job is to make sure people get taken care of. And if it's not at our firm, it needs to be somewhere. And that's the way it should be. I think Randy Sorrell said it once. We're going to fight like hell to get the case, but once you get the case, we want to have everybody win. And that's an important way to look at it.
Yeah.
But there are two things. One, making sure that you got the wheelhouse or you're in the right wheelhouse. And it doesn't happen. And the motivation on the fee is too compelling to certain people. A war story quickly. Someone asked me recently, can you take a look at a case?
No,
I said,
you
"Yeah, I can
take
look
as
at a
long
case."
as you want on the war story.
Yeah.
We are going to edit it out. No one will ever hear this.
That's
These
right.
poor victims are the only people
That's right.
who will ever
But
know.
what happened was it was a motivation by a lawyer that said, I can't get enough money. You can get more money, but wanted to pay me essentially a we haven't worked together deal. How about hourly? And I said, well, number one, I've been hired by Kurt Arnold, Tony Busby, Mo Aziz. I haven't been hired by Kirker Garcia yet to help on co-venture cases. I don't need to audition for you, I can assure you. So yeah, if you want to take the risk of not getting maximum value for your client because you're doing 40% of the math wrong, because you'd be doing 50% of 40% of the limit and you're doing 40% of a sublimit, that's bad math. But it was motivating and it's sad. The other thing that in addition to making sure you're getting right help on cases is this concept of if there's a reduction in available MVAs, what's going to happen? It's going to force people to look at their inventory and not assume every case, not just maybe a product's angle or a professional angle. Maybe it's a roadway design case that you're missing because you're not paying attention to that. It was a TxDOT roadway, and maybe there's a contractor that didn't follow TxDOT site plan, and you can overcome CPRC on the death claim or killing your case claim, and you can bring some creativity to bring in a different, that's an E&O claim, a different angle to your client's overall benefit. But just your cases in your book, don't assume, maybe you have time, maybe this will give people time to look at their docket and say, hey, this is a really big case. I'm missing an angle in my own case on a damage model or an element of the case it shouldn't be in the 30,000 bin or a low limit bin, even though there's insurance, but maybe you're not even paying attention to the right insurance. I mean, how many times are we in situations, Mr. Strike, where someone doesn't know to go get an excess policy or ask for an excess policy or follow through and make sure there's not additional coverage? And it's not just checking PIP and checking UM. There's legitimate opportunities people are missing because of the volume play is just churn and burn, churn and burn, churn and burn. And automation maybe will help people to pay better attention to their own dockets. Who knows?
Yeah, if you have more time to sit and think.
Yeah.
Yeah, I mean, we haven't talked about this, but like, as I understand it, Will gets a lot of his work from referrals from the rest of us, right? People are out there getting cases, and when they realize it's maybe a little bit above their pay grade, they talk to Will or they talk to, sorry, I got to do this, somebody like Kirk or Garcia. Slow down. Look at your cases because the cost of acquisition is going up. You're trying to run a profitable business. You should slow down and see what you can do that is the best that you can possibly do for the clients that you have, not the clients that you wish that you had or that you hope to get.
I think we should slightly change topic. And Josh, let's discuss what we've been doing the past couple of years that has really nothing to do with personal injury.
Yeah. Which is everything that we do has nothing to do with personal injury.
Everything.
So my background is, first of all, you guys, I'd like you to boo because we need like some sort of dramatic tension for the podcast version of this. I'm from Arkansas. Yeah, that's right. Okay. Woo, go Hogs. When basketball season starts, go Hogs. Yeah. I ran a wage and hour shop. We filed a lot of wage and hour cases over the years. I literally helped tens of thousands of people get paid properly. The margins started to go down with the proliferation of arbitration agreements, and I started doing some marketing for some consumer class action groups, including data breach firms. And I was doing that for like a year when Tommy and I linked up, and I told him what I was doing, and he said, oh, we could do consumer class actions in-house. And I had never thought of that because I just done employment cases. And so a year and a half ago, we started a firm together, and we started doing consumer class action cases, a lot of data breach cases, and some other cases. He may talk to you about that. But like we've put ourselves in a position where we've been able to help hundreds of thousands or millions of people in the last 18 months. And you guys have clients who are undergoing the same types of violations that ours are.
Yeah, I think in this new world, data is the most important thing that we have. And you see trillion-dollar companies left and right that don't charge their users anything. It's because they have the data. They make money on the data. And there are just blatant violations going on. Right now, I guess you can call them moonshot cases, but the biggest cases that we've been spending a lot of time on the last 3 or 4 months is we have data breach cases, even though it's tangentially related to data breach. We're suing basically all of the big LLMs, NVIDIA, Meta, Snapchat, TikTok, Runway, for their text to video LLMs. If you've ever gone on Sora or one of those apps that says, generate a picture of a chicken wearing a hat with a pistol, and it does it for you.
Wait, I think we haven't had some audience participation in a while. Show of hands if you've said, what? Generate a picture of a chicken brandishing a pistol?
Wearing a hat. But
a couple people.
But do y'all know what I'm talking about? Have y'all used the text-to-video LLMs, text-to-picture LLMs? Yeah.
But it wasn't necessarily a chicken with a pistol, right?
Yeah.
Okay, he keeps telling me that's the only thing people use it for, and I'm like, I'm not sure that's everybody.
Well, effectively, the cases that we have filed is if you look at the research papers published by these AI companies, what data sets they've used. And by reverse engineering that, you can see that their data sets that they're using are just publicly available YouTube videos. Now, when I say publicly available, if anybody's gone on YouTube, you can watch a YouTube video, but you can't download a video, you can't get the file to it. So what they had to do is create mass scraping tools to go and download literally hundreds of millions of videos. So the cases that we're most excited about right now internally are these class actions on behalf of YouTube creators that are in these data sets used to train these LLMs. So it has nothing to do with personal injury. The defendants are, the richest companies in the world that we believe are trying to make trillions of dollars off of the backs of people by taking their data and not paying for it. So it's a really interesting field. And,
Can I interrupt?
Yes.
Yeah.
I don't know what the hell you're talking about.
Oh, yeah.
Raise your hand if you know what he's talking about, because I don't know what he's talking about.
Yeah.
So
It's the future.
So what's the claim? Like, what's the
So
suit?
our claim, the claim is we've sued under the DMCA, which is the Digital Millennium Copyright Act. There's a law passed in the 90s. Under the DMCA, there's lots of provisions, but provision 1201 is the anti-circumvention provision. It's statutory damages. It says every time you circumvent the technological protection measures of a site to access their data, it's a $2,500 infringement. And we've calculated, like for instance, in NVIDIA that I was working on today, we've found that they've downloaded roughly 330 million YouTube clips. So if you times 330 million times $2,500, it's a lot of money. Now, we're obviously the very early stages of these cases, and I'm not suggesting that we're going to win, but these are cases that we believe are important. We believe they're not going away as LLMs are only going to get bigger. Data sets are only going to get more, expand and be pervasive. But we're trying to be at the forefront of this litigation. I'm sure a lot of people have seen the Anthropic settlement by Sussman Gottfried and Leif Cabraser. That was a case that in 11 months' time went from being filed to a $1.5 billion settlement. And that was a copyright infringement class, which we don't have here because YouTubers don't register their videos for copyright, but authors do. And the gist of that claim was to train the LLMs. Anthropic downloaded a data set of pirated books.
Yeah. So look, you all probably know that Tommy's a successful YouTuber. You probably don't know that I'm a failed YouTuber, because if you're a failure, it doesn't really show up in people's feed, which is nice. So you can't find me, but I am there failing quietly. But like, you all have like communities and constituencies and interest groups that are being touched in various ways by changes in technology. You have an opportunity to think like a lawyer and think like, is there a claim? Is something that's disrupting something that I care about giving rise to a potential lawsuit? The answer is a lot of the times, yes. Like, there's no guarantee, but like, there's a lot of rules out there, and you all care about things that I could not care less about. And you should like lean into those things and figure out, are there changes in technology or business that are happening that affect the people that I care about or the communities that I'm involved in that matter to me, and that there is potentially a legal claim for? Because the answer is sometimes, yeah.
Mike Strike.
Hit me.
Yeah. How do you logistically and administratively handle all those claims?
That's with respect to a class action, you just need, like, we filed with 3 plaintiffs, 3 class representatives. We are seeking class certification. If that's successful, what the court says is you represent this class, which we can identify because we can reverse engineer the data sets.
What venue?
Northern District, California.
And that's where you're going to be, because that's where they are?
We have 4 in the Northern District, California, 1 in the Southern District of New York.
Is there some federal Marshall-esque like division somewhere that you can jam your case into, like the IP guys all ran there?
No, we went to the home jurisdiction,
Yeah, we
but
went to
it
the home
is,
jurisdiction
fortunately,
to
it's
take
pretty
companies.
plaintiff friendly for some of them.
Yeah.
Yeah.
But the idea of us doing that 2 years ago, for 6 years, I was a single event PI and first party insurance guy.
And I was an FLSA, like unpaid wages lawyer. Like, you can figure out where there are clients and you can serve them. I mean, if I can do it, y'all can. Look at how bad I am at hosting a podcast. Edit that out.
Yes, ma'am.
Where is the language model supposed to be learning from if it can't pull from the public data? Like, what is protected and what's not?
So they're supposed to pay for what they train on, would be my representation. And it's not public data, at least with respect to YouTube, just because free does not mean public. I can go to the Manil and look at the Picasso for free, but I can't take the Picasso off the wall, right? Which is
It's frowned upon.
Yeah,
frowned upon. Yeah.
And there are different standards for different companies. Gemini is training on data that Google knows. Well, what does Google know? Google knows a lot that we've consented to, right? We
Right.
signed up, we gave them a bunch of access to our data, and
Google owns YouTube. So we
And
can't,
Google owns
so you
YouTube,
can't sue
so-
on behalf of
Yeah.
Nano Banana. Which is
Okay.
But-
I'm going to ask this question then. If you were doing wages and you were doing first party and single event, third party claims, what did you do? What was the epiphany sitting on the mountaintop saying, well, goddamn, man, here's this claim I'm going to bring?
yeah.
Like, what was that?
Well, for me,
In a sue everybody tour, be creative. What was
Yeah.
your inspiration?
Well, for me, I can tell you is how hard it is to get PI cases. I was averaging about $5,500, $6,000 per car wreck, and returning an average fee of $11,000, $12,000 after 2 years. And I had a big social media presence. Yes, I was very lucky. I got some big cases that came in my door. But that was the exception, not the rule. I was just really sick of how hard it was already, and I think it's only getting harder. So that's where when I linked up with Josh and we found a way to get cases at scale for a reasonable price, that's how our minds opened up to this.
Yeah, for me, it's like an obsession with helping as many people as possible. There's so many easier ways to earn a living than being a lawyer. Y'all are supposed to say amen. This is super weird that y'all didn't say that, but it's true. Like, there's so many ways to earn a living. Like, I wanted to help people, and the opportunity to help people at scale, to me, like, even if you're just doing a little bit, but to do that over and over and over is like that's super gratifying. Like, I like the idea of making even a little bit of a difference in the lives of as many people as possible. So yeah, I don't know. I'm a little bit of a sucker for that.
Question for you: if you had a pie chart of your docket, what percentage involve a vehicle?
I'm looking at Michael Brennan. I'm looking at Andy. I'm looking at Evan. 85%?
I would say 75.
75%?
Yeah.
75%. That's trucking, pedestrian auto, MBA. We don't have any products. Yeah. So yes, 75%.
And in post, will they add a pie chart to that? Because that was just a number.
Yeah.
Oh, okay, great, cool. I love pie.
So when you're going against, I guess, big tech, just as a general term, are you finding other big tech companies coming to you to say, hey, other big tech company is stealing from us? Can you represent us against other big tech companies? Is that something you're pursuing, or is that you don't want to create a conflict?
Yeah. So we haven't run into that because we just go through the consumer route, and for class actions, it's really the reverse. It's this creative thinking process where often you think of the case and then you go find the client after. In MVA, somebody gets hit and they call your office because they're injured. Here, it's you identify an issue and then you work backwards on, okay, I found a case. This is my plaintiff that I want to get. Let's go get that plaintiff.
I want to say a couple of things kind of principially. I know I've been here on the show to look sexy and be funny, but there's more to me than that. I'm actually a smart guy. And I would say that not being in a hurry is maybe the greatest favor you could ever do to your clients and to your partners if you have them, or to your employer if you have an employer. And just to sit and think, it's hard to overrate free time or downtime where you're actually like thinking about the problem that is facing you. There's this great quote from Einstein, who's just a little bit less smart than Will Moye is. And he says if he had an hour to solve a problem, he would spend 55 minutes thinking about the problem and 5 minutes thinking about the solution. As lawyers, we need to be more like that. Your clients are facing problems, and there are just like kind of problems in society. Think about those problems. Like, y'all are smart. I guarantee you, most everyone in here is smarter than I am. Just like, think about the problem, and there are opportunities that are available to all of us that break things open. That has like, I know you can't like.
Yeah, and I think tailing on what Josh said,
I started crying.
Your business is not going to be affected in the next 12 months, 24 months, 36 months. But 10 years from now, that's why we're starting this conversation now, so everybody can start thinking.
Will's thinking right now. We can't even get him to engage. He's like, I should be thinking.
I was thinking, how do you handle it with those guys on the other side when they hire Cravath and they've got 100 lawyers, not 100, 75 lawyers? How do you deal with that paper and that avalanche of shit they're throwing at?
I am not embarrassed at all to say that this conference here tonight, this podcast, is sponsored by Supio. I don't know if they planted you to say this.
How do you handle the data?
Let Supio look at your data and save your time. Like if you don't know in 2026 that a legal AI can ingest the documents that you have and tell you what you need to focus on and what you can't ignore, then you're an idiot and you need to turn your law license in. I'm not joking. Like, there are so many tools out there to, like, we are now, because of technology, we're on a level playing field with these guys who can just throw billable hours at you. We don't care about billable hours. Like, we're literally, like, our tiny little firm is taking on the biggest, highest dollar firms in the US, and it's like actually not intimidating. Just get competent AI, and if you're doing accident-based stuff, get Supio to look at the medicals. Get them to look at the document dumps from opposing counsel. Like, there really are like mechanical solutions to your everyday problems that you can resolve for great outcomes for your clients.
Pretty good segue, right?
Yeah.
Wow.
Yeah. All right. The last topic that I want to talk to you about, Will, is what is on the agenda for the legislature the next session?
How long do we have? So this is it's not a soapbox speech.
We just have 2 seconds, like 3 seconds.
They're trying to F us if it's 2 seconds.
Okay, that's the short version. You can clip that. That'll work.
Us including, 30 million Texans. So it starts now. TLR is the leading lobbyist group on behalf of the Weekly Brothers and others who for the last 25 years have dedicated a lot of money to the concept of abusive litigation and tort reform needs. They have $25 million in their war chest. I know that there are competing plaintiffs-leaning lobbying groups that are mindful of being able to compete with the money. There's some local PACs here that have started. There's obviously a TTLA and HTLA PAC that are asking for funds to compete against TLR's war chest. For the plaintiffs' lawyers in the room, the plaintiffs' lawyers watching this around the state, it doesn't start in 2027 when legislative session starts. It starts now. That we need to be offensive. We need to be mindful of. They're not going to make the same mistakes they made last time. So what happened last time was they presented bills in the legislature that were eviscerating essentially all categories of damages, eliminating legitimate injury claims, burns, amputations, disfigurement claims, just taking it off the table completely. The most compelling kind of social narrative was it required, in sexual assault cases, essentially a medical visit and a diagnosis of a medical intervention, which we all know is not possible in many, many instances. And that kind of allowed us to seize upon some of the Republican narrative of, well, this isn't going to work the way it's written. And then we had some folks retreat from the motivation to push that through. In 2027, they can start posting bills December 2026, so that's the end of this year. They will be more skilled in their motivations to limit instead of one macro omnibus. You don't get to have cases in Texas anymore. All injured Texans won't get paid a penny bill. They'll be methodical in addressing LOPs, separate from everything else. Evidentiary burdens, separate from everything else. Trying to combine damage limits, separate from anything else. There will be a masquerade of caps, but they'll be more diligent in not calling them caps. It won't be 3 times, 5 times, 6 times a certain damage element. It's going to be much more obtuse, but the end result's going to be a cap. And for those that don't know, the reason the first bill, and we all kind of, I think, shit our pants saying, wait, this is a 5 times economic or 3 times economic deal, that's a cap. Caps have to be approved by the voters. So if you go back in your time machine to MedMal, HB4, that was approved by the voters. So that's why there's a 250-500 cap in the Medical Liability Act. That would have been a problem for them to pass tort reform with a cap because it would have taken a need to vote. So they did some flexible language to make a cap not a cap, but in reality it was a cap. But they are 100% coming. If there's an opportunity, it's in a marketing pitch for your local legal organizations, but giving some money to a PAC is important. I'll speak not as a member of TTLA or HTLA, I'll speak as an observer of their political philosophy. It is no longer viewed as a partisan organization. It is an issue organization. Both organizations are issue organizations. The reason tort reform failed this year was because a group of populist Republican freshman representatives said, I'm not going to be a voice piece for this big TLR historical movement that's alleged to be pro-business. I'm not going to just read the bumper sticker of pro-business and embrace it and say it's right. They were more critical in their analysis of it, say that's not actually pro-business, and there's nothing wrong with populism. You know, if someone's injured and someone wants redress and someone has a right to a courthouse, someone has a right to stand up and say, hey, you got to pay the piper, you owe it. That's populism. And there was a band of Republican-elected populist, kind of Paxton versus Patrick crew, and there's a division within the Republican Party between our Attorney General and our Lieutenant Governor. But there were Republicans that voted against the Moody Amendment there was a omnibus bill that came through. It had an attachment to it called the Moody Amendment that would have limited some of the nonsense they were trying to pull. The House would have voted for it by 1 vote, and it did pass by 1 vote. It couldn't get reconciliation in the Senate, so it died. So tort reform died. Trucking never got out of the JCJ. Tort reform as the omnibus, you don't get damages bill, got out, got to the floor and got killed. And they couldn't reconcile in the Senate. But they're going to learn from their mistakes. So what's coming is this. They are going to attempt to legislate us out of business. They are trying to attack Texans. They're trying to attack Texans' rights to get to the courthouse, Texans' right to sue, trucking companies that hire foreign drivers and to sit in a political statement, anything other than if you're a foreign driver and you got a foreign CDL and you can't speak English and you haven't trained in Texas to drive on our roads, you shouldn't be freaking driving. It's that simple. This isn't a political message beyond other than turn the key to your truck on our roads at 80,000 pounds, do it safely, and learn to be doing it rightly. And they don't do it rightly, and they don't care. This is a political message that's stale, it's overused, of insurance this and insurance that. And we got a huge favor by Lee Parsley, who's essentially the mouthpiece for TLR, by going to the trucking bill and saying the following. What did he say? I can't promise you this is going to lower insurance rates. And holy shit, that helped us tremendously, because there was a bout of honesty about what this really was. It's not about premiums. It's not about helping Texans. It's about certain government entities pretending that this matters when in fact it doesn't. It's coming. Participate, and please go vote. Daniel Horowitz, go vote, right? Didn't that help? Doesn't it help to go vote for people that are going to make sure we protect the citizens of the state? Go vote.
And be involved in politics at the state legislative level.
Yeah, Dan Horowitz has not been paying attention for the last 4 minutes, but that's okay.
Well, you told me to shut up.
I did, and they did.
No, I did. I
Yeah.
was pretty clear about it.
So-
I didn't use his
so-
name. I was just like that guy with the vest.
That is the condensed version of a tort reform message.
Yeah, and like you all know, if you've been watching in California, Uber has put a lot of money behind the idea of kind of killing the ability to sue for actual harm in accident cases.
They did it here. Elon Musk had a Twitter fight with LaHood recently.
I mean, if they can get that done in California, if they can even get close, I'm telling you, they can get it done in Texas.
So Musk had a Twitter war with LaHood. LaHood's the gentleman in San Antonio who was he's a state rep, a Republican state rep, who killed trucking in the JCJ. So they didn't have votes to get it out. And Musk tweeted 2 weeks ago, hey, we got to make sure that I had a friend of mine who got killed by a truck driver who was untrained, didn't have a CDL, and was here illegally. And again, not a political statement on legal versus legality. It is a political statement of don't drive trucks on our roads unless you have a license. That's fair game. And Musk was raising hell about it. Well, Hood came on top in a Twitter fight saying, well, then don't give $1 million to TLR, because TLR is actually trying to promote trucking bills that means we can't try a trucking case. So for those unfamiliar with the trucking bill was taking bifurcation to new heights, and essentially meaning you can never try a direct claim against a trucking company ever again unless it's in the gross space. So if they hire a bad driver, they don't monitor, they exceed duty status, they're not doing anything to supervise, train, or retain, tough shit, it's a driver error case only. That was what they were trying to do. And Musk gave them $1 million. Yet he goes on Twitter to talk about the exact same thing the trucking bill is trying, what we're trying to make sure doesn't happen by killing a bad bill.
Yeah.
Can I curse on this? I've cursed a couple.
Yeah, no, Will. If we need to edit it out, we certainly will. I mean, there's no way Tommy's ankle is showing up in our video. This is like a family show, and he's showing so much skin. It's
I was going to tell
weird.
the crowd that we're deposing Elon Musk in the next 30 days.
Oh yeah, we actually are. So you guys might remember, like a year and a half ago, he had a
Banks did depose him?
Bankston has deposed him,
Yeah,
So, okay, wait, hold on. I'm going to stop there. Okay, we're going to wrap up this podcast.
No!
We're going to take a 15, 20-minute break. Anybody who wants to stay around, we're going to film a second podcast, and let's go get some drinks. That's what I want. All right.
Actually, hold on.